those of you who haven't seen Office Space, they are essentially destroying evidence in this clip. Which rule point 4A actually deals with right off the bat. So opposing counsel shall not destroy other evidence. And actually this says you cannot obstruct another party's access to evidence or alter it or destroy it or conceal a document or the material having potential evidentiary value for the purpose of obstructing a party's access to evidence. You also can't counsel or assist anyone in doing this. I actually had this issue come up today. And the ethics hotline is more than willing to call you back and tell you exactly what you need to do when you're faced with a situation that might potentially run afoul of this. This comes up sometimes in criminal defense practice where if your client comes to your office with a bloody knife, drops it on your desk, and you're charged with, well, what the heck do I do with this? You know, you can't hide it, you can't wash it off. And so that is in part what this rule deals with. If you're corporate counsel, you can't tell your client to cook the books. So B, you cannot advise or cause a person to leave the jurisdiction or not to testify. So if you know a witness to a client you're defending will deep six you at trial, you can't give them a one-way ticket to Schenectady. C, you can't falsify evidence. You can't forge stuff. You can't make it up. You shouldn't file bogus pleadings anyways. And you can't counsel or even assist a witness to perjure themselves. And you can't offer an inducement to a witness that's prohibited by law. So for a fact witness, you probably should not be paying them to testify. Paying their expenses of travel is one thing, but actually paying them to testify like an expert is something else. However, a lawyer may advance, guarantee, or pay reasonable expenses incurred by a witness in attending to testify, so you can pay their hotel room. Reasonable compensation to a witness for lost earnings as a result of attending or testifying. And Rule 3, which makes some practice areas possible, you can actually offer a reasonable fee for the professional services of an expert witness. How many of you in here have ever had an expert witness testify for free? Put your hands up. No one? Okay. You also cannot knowingly disobey or advise a client to disregard a standing rule or ruling of a tribunal made in the course of a proceeding. However, you can take steps in good faith to challenge the validity of such a ruling. So E, you cannot make a frivolous discovery request or fail to make reasonably diligent effort to comply with a legally proper discovery request by an opposing party. So if an opposing party sends you 3 rounds of interrogatories, you cannot wait to disclose everything in one fell swoop just because it would be more convenient. You actually have to respond to each set of interrogatories within the proposed deadline, or in good faith argue to extend the deadline with them, but you can't just sit on your hands. You're also forbidden from alluding to any matter in a trial that you do not believe is relevant or that you do not believe will be supported by admissible evidence. You are also not allowed to assert personal knowledge of facts and issue except when testifying as a witness. And finally, you cannot state a personal opinion as to the justness of a cause, credibility of a witness, or the culpability of a civil litigant, or the guilt or innocence of an accused. So how many of you have gone to court and seen the opposing party or any party stand up and say, well, Your Honor, in my day, we didn't do things like that, so this isn't illegal? Yeah, I'm sure most of us in here who have a trial practice have seen an argument where the other side actually takes on the onus and saying, or implying that they have personal knowledge in the matter. You can't do that. And part of the reasoning behind putting your own personal belief into an argument or into the justness of a cause or the credibility of a witness, especially if you're arguing to a jury, is putting yourself behind is very powerful. So if you're arguing to a jury and the jury has credited you over the other side and you are telling them personal knowledge, this rule says you have now crossed the line. You can argue from an objective standpoint, this cause is just, but you cannot say, I believe this cause is just and I know it's valid. I've seen the evidence and I know this is what you should do. You have now assumed the role of a witness as opposed to an advocate. And this rule tries to stake out a fair position that draws the line there to stop that blurring from happening. So a lot of more thou shalt nots. And there is another video for those of you who are starting to yawn. So you can't intentionally or habitually violate a rule of procedure or a rule of evidence if it's disruptive of the proceedings. You also cannot request a person other than a client to refrain from voluntarily giving relevant information to another party unless the information is relevant in a pending civil matter, unless the person in a civil matter is a relative or current and former employee of another agent of a client, and so these are conjunctive requirements, these are not disjunctive, and the lawyer reasonably believes that the person's interests will not be adversely affected by refraining from giving such information. So what does this rule mean? You can't tell a person other than your own client to not talk to the other side. This comes up some in civil cases. It comes up, frankly, a little bit more in criminal cases. If you're prosecuting a case, sometimes the victim will come up to you and say, hey, should I talk to the defense bar? You cannot tell them, oh, no, don't talk to them. If you do that, you've broken the ethical rules, and you can be disciplined for that. What some of the LEOs will flesh out later is you essentially have to tell them of this rule. You know, you're not obligated to talk to them, but I'm not going to tell you not to talk to them. So it is a fine line to walk, but you do have to know this rule so you don't run afoul of it. There's an exception for civil cases that involve employment. So if you're representing a company in a civil action, you may be able to tell your employees or the company's employees, please don't talk to them until we've settled out a few of the details. However, they have to meet each of these three requirements. So the information would have to be relevant. They have to be a relative or current or former employee of an agent. And most importantly, you have to believe that you wouldn't be hurting them by telling them don't talk to the other side. You cannot present or even threaten to present criminal or disciplinary charges solely to obtain an advantage in a civil matter. This does not mean that you cannot threaten to or present other civil causes of action in a civil matter. This means you can't threaten the other party to file a bar complaint on them or to have their client charged with a crime to gain an edge in a civil proceeding. This potentially can arise in family law cases. One party says, oh, my husband is beating the tar out of my child. I want you to charge him to help my divorce. You can't do that. And there is a comment down below that tells the attorney what you can do in that circumstance, but you have to, as a civil attorney, keep the criminal and the criminal and discipline out of your civil case. You should not allow them to contaminate your case or try and use them to your advantage. So J ties into the Canvas case, but you can't file a suit, initiate criminal charges, take a position, conduct a defense, delay a trial, or take any other action on behalf of your client when you know or when it's patently obvious that the only purpose of that action is merely to harass or harangue the other side. So even if it's a proper action, even if you're allowed under the rules of discovery to file 2,000 requests for admissions on the other side, if your main purpose is to harass them into submission, you can't do that. Okay. So comment 1 deals with our adversarial system. We do have an adversarial system. We operate on the fundamental assumption that each side will marshal the best of its case and try and distinguish the worst of its case from the other side. Since we are adverse to one another in the courtroom or in a case, we need some ground rules so that we don't devolve into mortal combat. So, number 2, a kind of obvious statement, but documents and other items are essential to establish a claim or defense. So unless a privilege covers the document, the item, the bloody knife, the severed hand, the right of the opposing party, including the government, so if you're a defense attorney, you probably can't withhold the bloody knife from the government. To obtain the evidence through discovery or subpoena is an important procedural right. The exercise of that right can be frustrated if relevant material is altered, concealed, or destroyed. So applicable law makes it an offense to destroy material for the purpose of impairing its availability in a pending proceeding or one whose commencement can be foreseen. So this last clause is important. If you have an item, a bloody knife, a smoking gun, even if there's not an active criminal investigation going on, if you hear sirens in the background, it's reasonably foreseeable that a commencement is going to happen. So if you can foresee it becoming an issue, if there might be a complaint floating around, all of these rules are still at play and you can't destroy the evidence. It becomes evidence, therefore you cannot destroy it. So 3, with regard to paragraph C up above, it's not improper to pay a witness's reasonable expenses or to pay a reasonable fee for the services of an expert. It then goes into the common law rule that you should not pay an occurrence witness, a fact witness, only for testifying. And it's also improper to pay an expert witness a contingent fee. So you can't tell your expert, I'm only going to pay you if you win me the case.
Your Honor, I object to this witness. Improper foundation. I'm not aware of this person's qualifications. I'd like to voir dire this witness as to the extent of her expertise.
Granted. Mr. Trotter, you may proceed.
Oh, Ms. Vito, what's your current profession?
I'm an out-of-work hairdresser.
Out-of-work hairdresser. Now, in what way does that qualify you as an expert in automobiles?
It doesn't.
Well, in what way are you qualified?
Well, my father was a mechanic. His father was a mechanic. My mother's father was a mechanic. My 3 brothers are mechanics. 4 uncles on my father's side are mechanics.
Ms. Vito, your family's obviously qualified. But, have you ever worked as a mechanic?
Yeah, in my father's garage, yeah.
As a mechanic? What you do in your father's garage?
Tune-ups, oil changes, brake relining, engine rebuilds, rebuild some trannies, rear ends.
Okay. But does being an ex-mechanic necessarily qualify you as being expert on tire marks?
No. Thank you. Goodbye.
Sit down and stay there until you're told to leave.
How many of you would pay that witness for coming? Okay. Comment 3A. The legal system depends on voluntary compliance with court rules and rulings in order to function effectively. So generally, you can't break the rules. If you know about the rule, it's an established court rule, you can't break it. However, paragraph D allows you to take measures necessary to test the validity of a rule or ruling, including open disobedience. So I suppose if a court has made a specific ruling on a case, such as a gag order perhaps, and you think the gag order is unconstitutional, D allows you to take measures reasonable to test the validity of the rule. So you can file an interlocutory appeal. You might be able to protest. This is a truly fact-intensive determination, so without the situation in front of us, can't really tell you what would be or wouldn't be proper. However, understand If it is a long-established rule, you should not be breaking it. So this has to do with the fact that you can't tell other witnesses not to talk to the other side. The rule contains an exception permitting lawyers to advise current or former workers or other agents of a client to refrain from doing that because those people may have a common interest with the former employer or the former client. So a family member probably going to have a common interest with your client. If your client is a big employer, all of the employees may also share a common interest. They may not. The exception is limited to civil matters because of concerns with allegation of obstruction of justice, including perceived witness intimidation that could be made in a criminal investigation and prosecution. Again, that is reasonably straightforward. So, you are not allowed to present criminal charges or threaten them, or ethical charges or threaten them solely to get an advantage in a civil case. However, you're able to advise your client about the possibility of criminal prosecution and the client's rights and responsibilities in connection with that prosecution. So if your client comes up to you and says, hey, my husband is beating the living tar out of my kid, I want you to charge him with a crime, you have to say no, really for two reasons. One, it's unethical to do it solely to get an advantage in the divorce. Secondly, as a private party, you can't bring a criminal charge. The Commonwealth has that right of action. However, what you can do is you can tell them, hey, I think this violates the applicable statute on assault and battery. You think maybe it violates the law. You can tell them how to take charges. You can tell them, hey, if it's misdemeanor battery, you can go to the cops, or you can go to the magistrate's office and actually file your own warrant. And then you can tell them what their rights and responsibilities as a witness would be. You say, hey, if you file your own case, you're going to have to show up to court. You're going to have to check on the court website for the court date, the court time, and you're going to be responsible for getting yourself there versus if the police take the case, you can walk them through the system as a victim witness advocate would do. So J deals with conduct that harasses or maliciously injures another. It says that dilatory practices bring the administration of justice into disrepute. Delays should not be indulged merely for the convenience of the advocates or solely for the purpose of frustrating the opposing party's attempt to obtain rightful redress or repose. It's not a justification that similar conduct is tolerated by the bench and bar. The question is, when you're seeking a continuance or a delay, whether a competent lawyer acting in good faith would regard the course of action as having some substantial purpose other than delay. So, how many defense attorneys do we have in here, criminal defense attorneys? Any other brave souls? Wow, okay. Oh, Ed isn't here, sorry. So, you have a criminal trial the next day, and you walk into court and you ask for a continuance. Very common situation, happens all the time. As a prosecutor, I have seen one case that I handled that had been pending since I was in law school that had been more than 5 years previous. So cases can delay. However, when you make your motion for a continuance, if your motion is only to delay it, you're hoping the other witness croaks, they get tired of coming, that's not a proper purpose. If you've all of a sudden found out about a new witness, that's a good reason to continue it. If you were up the night before with food poisoning and there's no way in the world you're going to have the physical resources to stand up for a 2-day jury trial and give your client the competent defense you're constitutionally required to give, that's another good reason for a continuance. But just delaying for the sole purpose of delaying is not ethically permissible. All right. So 7, the exercise of professional judgment on those decisions which are for the lawyer's determination in the handling of a legal matter. A lawyer should always act in a manner consistent with the best interest of a client. However, when an action in the best interest of a client seems to be unjust, the lawyer may ask the client for permission to forgo such an action. This balances your duty to represent the client with zeal against your concurrent obligation. So you also have an obligation to treat the other side of the judicial process with fairness and to refrain from inflicting needless harm. So under this rule, you couldn't ask any question that the lawyer has no reasonable basis to believe is relevant to the case or that is intended to degrade any witness or other person. So if you have an unlawful detainer action, and you represent the landlord and you're just trying to get the other person out of there, you can't ask the other party on the stand how many different people of differing sexes have they had sex with over the last 2 weeks. It doesn't really have any bearing to the action. The only purpose would be to harass or to shame the witness. You can't do it. So 8, mercifully the last comment on this rule. In adversarial proceedings, clients are litigants, and though ill feeling may exist between the clients, that shouldn't influence a lawyer's conduct, attitude, or demeanor towards opposing counsel. A lawyer should not make unfair, derogatory, personal reference to opposing counsel. So like you saw in the Jim Carrey video, his quip to the other counsel, you probably shouldn't do that. Haranguing and offensive tactics by lawyers interfere with the orderly administration of justice and have no proper place in our legal system. A lawyer should be courteous to opposing counsel and should accede to reasonable requests regarding court proceedings, settings, continuances, waiver of procedural formalities, and similar matters that don't prejudice the rights of your client. A lawyer should follow the local customs of courtesy or practice unless you give timely notice to opposing counsel with the intention not to do so. You should also be punctual, on time, and fulfilling all professional commitments. So this is the be nice to opposing counsel rule. In other words, what this tells you, and it says should, does not say shall, but it says you should. If the opposing counsel comes up to you and asks for something in the case, hey, I need an extra week to turn over discovery. I'm going to get it to you. I just need a week. Hey, I need a continuance. My grandma died. The funeral, they set the funeral on the trial date. I tried to get it set elsewhere. This comment says, if your client's rights aren't prejudiced by it, you should probably agree to those. You should not ratchet up the rancor and the contestedness of a case beyond what it needs to be. So this is sort of the talk you off the cliff rule. You should be on time. You should be courteous. You should follow all of the local customs of courtesy and practice, which here in Virginia, we do have a very courteous bar. I'm not from here. I'm actually from another state originally, and I can tell you not every state has the same local customs and courtesies that attorneys give to each other. We do stand as a state that does. So follow those. Sometimes they'll work out to your advantage when you need the continuance to go to a funeral as well. Moving on to the LEOs. You, as a lawyer, cannot tell the other side's expert witness not to testify. This whole don't tell other parties not to give evidence, you can't tell them not to testify. Even if you did, they would probably very politely tell you to get lost, jump in a river, because it means they won't get paid, but you can't advise them not to testify. You also cannot hire an expert solely to harass the other side's expert. And what happened in this LEO is one of the parties had hired an expert. The other party hired that expert's boss. And there was not a specific request in that case to not have them testify, but it did draw into this situation, the committee did, when it said, as a lawyer, you can't do it, therefore you cannot direct your expert witness to do it as well. The mere hiring of their boss doesn't infer that, but by the way, guys, don't do it. So they did recognize that risk was there. Pardon me. Okay. How many people in this room have left a file laying out in a room with other attorneys. Yeah, how many people have left their briefcase full of open files at the seat to go up to the podium and talk to the judge? Okay, this is that LEO. In fact, my briefcase is over there. Good luck getting into the password-protected electronic files they're in, but it's still over there. This basically says it's improper for an attorney to raid the other party's file. One would hope that was obvious, but they go on to say you can't obtain information and documents from a former employee of adverse counsel in pending litigation, or for an attorney to review an adverse counsel's file which was inadvertently left in the attorney's office after depositions. If such conduct is deliberately wrongful or is conduct involving dishonesty, fraud, deceit, or misrepresentation. So, lawyer comes to your office for depos, leaves the file there, you can't rifle through it. And in fact, LEO 1702 specifically forbids you from doing that, and also charges you with the obligation of giving it back to them. So LEO 768, we've had one LEO so far, don't lie in discovery. This is the second LEO that also says don't lie in discovery. It is improper for an attorney to prepare answers for interrogatories which misrepresent the identity of an expert witness and the substance of the evidence to be offered in a medical malpractice claim. So do not lie in discovery. Okay. LEO 1477 involves a lawyer. They're preparing to negotiate with the opposing party. During the course of that preparation, they learn that their previous discovery answers are no longer correct. So they require supplementation. And the discovery answers were signed under oath. What this LEO says is if you come to find out your discovery is no longer true or it is so incomplete it needs supplementation, not only do you have to supplement it and correct that problem, but you also cannot attempt settlement until supplementing discovery. So if you're in a divorce case, you're headed to that judicial settlement conference, and you know your client fibbed on one of those rules, you can't just sit there and be quiet, because that would involve fraud. You cannot withhold the ream of documents that your client just gave you. You have to supplement and probably would have to delay the judicial settlement conference as well. And so Rule 3.3A2 and also 4.1b require you to disclose facts if it's necessary to avoid assisting a client's fraudulent acts, and 4.1b is you can't assist in their criminal acts. Okay. LEO 948. This is the you cannot cook the books LEO. If you have a medical expert in a personal injury case, you cannot tell them to alter existing medical records even though no pleadings have been filed. So this has to do with you cannot do yourself or counsel another to falsify or amend records because you, with this fact pattern, reasonably believe they're probably going to be the subject of a dispute. And it's sort of a logical tautology here. If you have to ask the guy, hey, can you amend these medical records, they're probably going to be relevant anyways. So don't do it. You can't. Okay. I read LEO 839, and I see what it says. I'm going to read it up there, but I think the Legal Ethics Committee notes are more probative here than the actual LEO. So the LEO says, it is not improper for an attorney representing the wife in a divorce action to advise the wife to destroy phone bills that indicate she placed calls to another man in whom she became interested in 4 months after separating from her husband. The wife was under no obligation to produce or provide the telephone bills. How many divorce or family lawyers in here would want those phone records? Raise your hands. Yeah, all of you should have your hands up. I want those phone records now. So the committee notes say, under Rule 3.4a, the lawyer cannot advise the client to destroy the telephone bills if it is foreseeable that the bills would be relevant evidence in the planned divorce action. So this is sort of a rule of common sense. The way to think about it is, if you are on the other side, would you want this evidence? If the answer is yes, you should not tell your client to destroy it. Now, you can tell your client to refrain from conduct that produces evidence. You can tell them, don't post on social media. Don't make the phone calls to your lover. Don't do that. But you can't tell them to destroy evidence once it's in existence. So I think in this particular case, perhaps at the time the LEO was written, it wasn't always foreseeable the other side would request the phone bills. I would say in today's modern era, it is imminently reasonable and almost inevitable you're going to get a discovery request for phone bills in a divorce case, so you should not tell them to destroy the bills. Okay. LEO 1862, unfortunately, our prosecutor has left the room, but we do have a defense attorney in here or two. And LEO 1862 defense attorneys is your new best friend. And I will tell you, before I left being a prosecutor, I was starting to get discovery motions based on this standard as opposed to Brady. So it is extremely important. LEO 1862 essentially says, if you're a prosecutor and you discover exculpatory evidence or information, and you think it's exculpatory, Brady requires you to turn it over. Rule 3.8D also requires you to turn it over. However, Rule 3.8D is vastly more inclusive than Brady. So it says a prosecutor cannot withhold the evidence merely because his legal obligations pursuant to Brady have not yet been triggered. You have an ethical duty of disclosing exculpatory evidence in a timely manner. That duty compels earlier disclosure than the Brady standard requires. It says prosecutors have to get a court order that relieves them of their ethical duty to disclose exculpatory evidence if they believe the disclosure might jeopardize an investigation or a witness. Even if you lack a duty under Rule 3.8D to advise a defendant of a main witness's death or unavailability, the prosecutor cannot make a false statement about the availability of the witness. So in the fact pattern, believe one of the witnesses had died for the prosecution. Now, this LEO admits discussions of a prosecutor's silence to the matter in negotiations or to the court. However, the ethical rules require you as a prosecutor, I know I don't have any in the room anymore, but if we do have any that are listening, Rule 3.8D is more expansive than Brady. And it requires you to timely disclose are the words, any exculpatory evidence or information that you receive. So not just under the Brady standard evidence that would influence the course of a trial, but any exculpatory evidence or information. It doesn't even have to be evidence. Just information that you receive. You have an ethical obligation beyond Brady, beyond the rules of discovery, to turn that over in a timely manner. What's a timely manner? Probably as early as is reasonably practical. Now, it gives the prosecutor a way out if this information would jeopardize an investigation. So let's say you have an ongoing criminal investigation. You may not even be involved in the case as a prosecutor. But if you are, you need to get a court order that relieves you of that. If disclosure of exculpatory information, such as an address or a location of a witness, would jeopardize the witness, you also have to get an order relieving you from that obligation. So, I've said this before, I've gotten discovery motions that require the parties to comply with this standard. Now, I don't practice criminal law in Virginia Beach. I've left the criminal arena. But I'm seeing these motions start to pop up. This does have implications for non-open file discovery jurisdictions. It has ethical implications for non-open file discovery. So if there are any prosecutors who are watching, be extremely cognizant of this rule. If we have defense attorneys, also be aware of this rule, because it greatly expands your access to information if you know how to use it. I mean, obviously, you're not necessarily going to know what's in their file to know if they've complied with this, but I've seen these discovery motions come up. It's frankly not a bad idea. And the ABA opinion 09-454 is essentially this exact opinion, but under the guise of the ABA. So requires timely disclosure to defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense in connection with sentencing or guilt. Disclose to the defense and the tribunal all unprivileged mitigating information known to them. So this ethical duty, it's separate from disclosure obligations under Brady, under statutes, under the procedural rules. This is a standalone, ethically motivated duty for the prosecutor. Basically, if it's information that is remotely exculpatory, might it hurt your case, might it help the defendant for sentencing, you have to turn it over in a timely manner. Doesn't say what timely is, but you have to turn it over. Oh, and it also gives an obligation to supervisory personnel under Rule 5.1 to ensure that their underlings do that. So LEO 1795. This is the how to treat. This deals with communicating with witnesses and whether or not you can tell them not to speak to the other side. So it presented 4 questions. Defense attorney asked the victim or mother if he could speak with her before she spoke to the Commonwealth. It then had the question of, can the defense attorney tell the victim or mother that she did not have to speak with the Commonwealth attorney? It then said the defense attorney had told the victim and father that he had checked the court's file, and as there was no subpoena, the father was free to leave. And finally, the defense attorney had told the victim or parents that if the father left the courthouse, the Commonwealth attorney would lose the case due to the absence of the father's necessary testimony. Do any of these present an ethical violation is what this asked. And it essentially said no. Under this specific ethical rule, they did not. So, as an attorney, you can ask to speak to one witness before the other side does. There's nothing prohibiting you from doing that. You can also, you can tell them they don't have to speak to the other side. You can't tell them don't, but they don't have to speak to the other side. You can check the court's file and see if there's a subpoena and advise someone that they're free to leave. I will say within the LEO does find some fault with these things. One of the faults it finds is that the attorney is starting to advise people other than their client. So none of these violate the prohibitions in Rule 3.4, but they may and probably do violate other provisions. If you're advising someone not your client that they're free to leave, you shouldn't be doing that because they're not your client. And number 4, the LEO did not find anything wrong with that under the guise of Rule 3.4. Memory serves, it did find it was advising a party, not your client. I would also add that if a prosecutor walks up on a defense attorney doing this, they're probably not going to be very pleased. There's something about some of this conduct that may rub some the wrong way. But the LEO said it didn't violate Rule 3.4. However, LEO 1741, I think, gives a better way of dealing with the problem. So it said the committee believes it's not improper to inform Commonwealth witnesses that you might be contacted by private investigators working for the defense. So this deals with from the other side, where the prosecutor's office is telling their witnesses. And they're telling them, hey, you might get contacted with PIs working for the defense. It might be Joe Smith. Joe Smith's going to call you. The committee believes it's not improper for a prosecutor to inform his or her witnesses they have the right to speak or not speak with an investigator. But beyond that, the committee believes Rule 3.8c prohibits the prosecutor from making any remarks, including the references to the questionable tactics employed by some investigators that would explicitly or implicitly instruct or even encourage a witness to withhold information from the defense. So this LEO turns out entirely different than the other one on facts that might seem to be similar. So you have an aggressive private investigator They may be employing some shady tactics, but the committee essentially says, look, beyond telling him, hey, you might get a call from this guy, and you can speak with him or not speak with him. That's your right. So the prosecutor shouldn't tell him anything else. I think in terms of protecting your license, this is probably the safest LEO to rely upon. So you have the right to talk to him, you have the right not to talk to him. That's your call. Period, the end. Okay. LEO 1338, false accusations are unethical. That sort of ties into the grand theme today of don't lie. But say groundless assertions of unethical conduct are unethical. So if you have no basis upon which to base your accusation, don't make it. And Womack versus Yeoman, a court actually sanctioned someone for doing just that. So